Hi, my name is Kim Whaley. I'm founder of Whaley Estate Litigation Partners, and today I'm going to do a virtual presentation on our new elder law book that we just published and has been released in March. Given the current COVID-19 challenging issues facing seniors and older adults in our community today, this presentation is probably more relevant than it may well have been in March. And so I hope to be able to provide you with some tools and resources to guide you through and navigate some of these really challenging issues. Thanks. So let's get started. While lawyers, of course, have always addressed particular issues faced by the elderly, in the past, issues affecting older adults or clients were more usually only a small part of a lawyer's practice. However, with changes in demographics, the proportion of older people in the population has increased significantly in recent years. Consequently, issues affecting the elderly have become much more prominent, and society, including lawyers, must continue to take proactive steps to address them. Elder law covers a lot of ground in terms of subject matter, but in general addresses any laws and issues affecting older adults with a focus on protecting the elderly or vulnerable and ensuring access to justice. As part of our ongoing efforts to address these issues at our firm, we published this book, of course, on elder law, and as I said, it's available for download on our website under the Resources Publications page. This presentation will address some of the issues discussed in our book, as well as some recent issues affecting older adults that have come to light just due to the COVID-19 pandemic. In order to understand the importance of current elder law issues, we must examine current trends in our demographics. Our population is aging rapidly. Globally, we are facing the largest demographic shift in history. According to the data from the United Nations World Population Prospects, the 2019 revision, by 2050, 1 in 6 people in the world will be over 65, up from 1 in 11 in 2019. In 2018, for the first time in history, persons aged 65 or above outnumbered children under 5 years of age globally. The number of persons aged 80 years or over in the world is projected to triple from 143 million in 2019 to 426 million in 2050. Closer to home, in 2019, there are more than 6.5 million Canadians over the age of 65 years and over 10,000 centenarians. According to various projection scenarios, the proportion of seniors aged 65 plus in the population will increase from 17.2% in 2018 to 29.5% in 2068. The increase in the number of seniors is expected to be the most pronounced between 2018 and 2030, a period during which all members of the baby boom cohort will reach 65 plus. The number of older seniors aged 80 plus will continue to increase rapidly in the coming years, particularly between 2026 and 2045, again as the baby boomers enter this age group. In Canada, a man's life expectancy is now age 86, while a woman's life expectancy is now 89. According to the most recent statistics from the Alzheimer's Society Canada, there are over 1.5 million Canadians living with dementia, plus about 25,000 new cases diagnosed every year. By 2031, that number is expected to rise to 937,000, which is an increase of 66%. Dementia refers to a set of symptoms and signs associated with a progressive deterioration of cognitive executive functioning that affects daily activity. It may be caused by a number of medical illnesses and conditions, including disease and injury. Alzheimer's disease is the most common cause of dementia. According to the United States Alzheimer's Society, Alzheimer's is the 6th leading cause of death with no cure. 5.8 million Americans are living with the disease. By 2050, it's projected that this number will rise to 14 million. Every 65 seconds, someone in the U.S. develops this disease. In coming years, there will also be a significant transfer of wealth between the saving generation and the baby boomers. Some may choose to transfer that wealth while they're still alive and are capable and have every right to do so. However, some may not have the requisite decisional capacity to gift their savings away, or they may be unduly influenced or coerced into doing so. With these statistics in mind, I'll provide a general overview of some of the more common issues in elder law, including elder abuse, in particular financial abuse, and relatedly, power of attorney issues and misuses, as well as common and increasing scams and frauds targeting older adults in our community, and some brief comments on COVID-related developments in wills and estates respecting virtual will and POA document signing, which is now permitted during this pandemic. One aspect of elder law is elder abuse. Elder abuse is a serious problem in our society and one that is likely to increase as our population continues to age, and one that is prevalent given this period of isolation from the pandemic. There is not a single comprehensive definition for elder abuse, although a few key related organizations have developed or adopted a definition for elder abuse and neglect. The World Health Organization defines elder abuse as a single or repeated act or lack of appropriate action occurring within any relationship where there is an expectation of trust which causes harm or distress to an older person. The Advocacy Center for the Elderly in Toronto defines elder abuse as harm done to an older person by someone in a special relationship to the older person. There are several types of elder abuse, including, for example, physical abuse, which are actions or behaviors that result in bodily injury, pain, impairment, or psychological distress, like slapping or pushing, beating, or forced confinement. Financial abuse, an action or lack of action with respect to material possessions, funds, assets, property, or legal documents that is unauthorized or coerced or misuse of legal authority. Sexual abuse, direct or indirect involvement in sexual activity without consent. Emotional, psychological abuse, where there's severe or persistent verbal or nonverbal behavior that results in emotional or psychological harm, for example, treating an older person like a child, insulting, frightening, threatening them, or ignoring an older person. And finally, neglect, a repeated deprivation of assistance needed by the older person for the activities of daily living. For example, failing to give an older person food, medical attention, or other necessary care, or abandoning an older person in their care. Focusing for a moment on financial abuse involving power of attorney documents and fraudulent scams perpetrated against older adults, our Federal Department of Justice reports financial abuse is the most commonly reported type of abuse against older adults, but it's underreported. Often the financial abuse is perpetrated at the hands of a family member whom the older adult is dependent on, and that perpetrator has influence or control over the adult victim. Adult children who harm their parents may have various health issues of their own, including possible mental health, substance abuse, social isolation, employment issues, and may have developed financial dependence on the older person. This requires a bit of investigation. The abuser may rationalize this abuse, thinking they deserve the money because they are the older adult's child. Financial abuse can also be perpetrated at the hands of a caregiver, a service provider, or other person in a position of power or trust. Abuse is underreported, both to the police and other support persons, for several reasons. Why? The older adult feels shame or embarrassment for having been victimized, is fearful of the perpetrator, has a fear of police or authorities, is dependent upon the perpetrator for physical well-being, protects the abuser, especially if the only family member or friend that is available to the older person for protection. The older adult may feel that an unhealthy relationship is better than no relationship at all. A coping mechanism may be to minimize or rationalize away the abuse or deny it altogether. Some may not even recognize it as abuse. Fear of loss of independence if abuse is reported is a big factor. Fear of loss of the long-time family home or being placed in a care facility, worried about family stigma, resistance to having strangers in the home to provide services, or others may not be able to report even if they have the desire to for reasons of physical incapability to report or resulting from mental incapacity. Two further forms of financial abuse include the misuse and abuse of power of attorney documents and scams targeting older adults. So, on power of attorney documents, as people age, more and more individuals are, or should be, turning their minds to planning for future illness, disability, or incapacity, and the consequential impact on their financial and personal well-being. The power of attorney document has long been viewed as one way in which a person can legally protect their future health and financial interests by planning in advance for incapacity. While we often see attorneys use the powers bestowed upon them as a means to provide the physical, emotional, and financial care that their vulnerable loved ones need, we have also seen these documents used abusively, causing the grantor harm through fraud, neglect, and depletion of wealth. The two power of attorney documents used in incapacity planning are the continuing power of attorney for property and the power of attorney for personal care. A power of attorney allows a person of the grantor's choosing to make certain decisions on their behalf. Specific legislation governs powers of attorney in Ontario, including the Powers of Attorney Act and the Substitute Decisions Act. It is, however, important to understand the different types of power of attorney. The first type of power of attorney is a general power of attorney, which is used for short-term or fixed time and often for a limited specific purpose. So, for example, if someone was going on vacation and needed someone else to look after their banking while they were away, or to complete a real estate transaction, this type of power of attorney does not remain valid if one becomes incapable at a future date. The attorney can no longer act once the fixed or limited purpose has been carried out. Another type, the second type we'll call it, is the continuing power of attorney for property, and it's used to make certain that one's financial affairs are looked after when a person is unable to do so personally, either on a temporary or permanent basis should one become incapable. Under the law, what makes a power of attorney a continuing power of attorney document, sometimes in other provinces it's called an enduring power of attorney, is if the document states that it is continuing, or the document expresses the intention that the authority given may be exercised during future incapacity to manage property. However, one must ensure to appoint an attorney and to execute a continuing power of attorney for property before becoming incapable of granting the document. A person is considered capable of granting or revoking a continuing power of attorney for property if possessing knowledge of what kind of property one has and its approximate value, has awareness of obligations that one may owe to dependents, knows that the attorney will be able to do anything with the property that the grantor could do if capable, except, importantly, making a will, and know that the attorney must account, in other words, explain and provide proof of all transactions and dealings with the grantor's property. Additionally, one must know that if one is capable, the continuing power of attorney for property may be revoked, and appreciate that unless the attorney manages the property prudently, its value may indeed decline, and appreciate the possibility that the attorney could misuse or abuse the authority granted. To be clear, these are the criteria to assess whether a person can grant or revoke a continuing power of attorney for property, and they are not the criteria to determine whether or not a person has the requisite decisional capacity to actually manage their own money or make decisions about their own property. Those are different decisional capacity criteria. In order to be considered capable of managing your property, one must have the ability to understand the information that is relevant in making a decision in the management of one's property, and the ability to appreciate the reasonably foreseeable consequences of a decision or a lack of decision. Much to the surprise of many, the powers granted to an attorney under a continuing power of attorney for property are extensive. An attorney has the power to do anything on the grantor's behalf that the grantor could do, if capable, except make a will. Again, to the surprise of many, this I'm going to call the continuing power of attorney for property a CPOAP in short. It's effective immediately upon signing, unless there is a provision or triggering event set out in the document. For example, that the document will only take effect on a certain date, or a certain event, such as incapacity. In that case, there should be a mechanism to determine incapacity, and if not the legislation, the Substitute Decisions Act offers some guidance. The third type of power of attorney I want to speak about is the power of attorney for personal care. This permits a capable person to appoint a person or persons to make personal care decisions on the grantor's behalf in the event of a finding of incapacity of being able to do so. An attorney under a power of attorney for personal care, I'm going to refer to it as a POA/PC, is not a care provider, rather a decision maker. A person is capable of making one's own personal care decisions if able to understand information relevant to one's own health care, nutrition, shelter, clothing, hygiene, or safety, and if capable to appreciate the reasonable, foreseeable consequences of a decision or lack of a decision. The legislation once again sets out the criteria for granting or revoking a POA/PC, which is different from the requisite capacity to make personal care decisions. One must have the ability to understand whether the proposed attorney has a genuine concern for the person's welfare and an appreciation that the person may need to have the proposed attorney make personal care decisions for the grantor. A person may be able to grant or revoke a POA/PC even if one is not capable of managing one's own personal care decisions. Remember, different criteria apply depending on the decision being made. An attorney under a POA/PC must make decisions in accordance with the legislation, including, in Ontario, the Substitute Decisions Act and the Healthcare Consent Act with respect to decisions about treatment. Also, an attorney under a POA/PC must use reasonable efforts to act in accordance with the grantor's wishes or wishes given while still capable. We call these prior capable wishes. And also in accordance with the Healthcare Consent Act, to act in a person's best interests. To act in the best interests, the attorney must consider the grantor's values and beliefs and whether the decision will improve the standard and quality of their life or otherwise prevent it from deteriorating, or whether the benefit of the decision outweighs any risk of harm to the incapable person. Written wishes and oral wishes are equally important, while later wishes take precedence over earlier ones. One of the downsides of a POA/PC is that the document often does not contain enough detailed instruction, or the instructions are far too detailed and cause confusion. On this note, I would refer you to a website by Dr. Whaley, which addresses a patient's planning wishes, which can be reduced into writing into a power of attorney document. Dr. Whaley's details can be found on our website. If a person has not executed a continuing power of attorney for property or a power of attorney for personal care while capable of doing so, and is later found to be incapable of managing property or making personal care decisions on application to the court, a court may appoint a guardian to make these decisions. The decision about who will make decisions on a person's behalf is no longer their own once becoming incapable of granting a power of attorney. The court process for appointing a guardian can be a lengthy, costly, and sometimes contentious process, especially if there's a dispute about who should act as a guardian amongst family members. Therefore, it's prudent for all to consider executing a power of attorney while able to do so. So now let's look at some common scenarios of misuse and abuse. So let's first talk about whether in a situation where a grantor grants a power of attorney while incapable of doing so, what the ramifications can be. So for example, the power of attorney could be fraudulently procured from a vulnerable or physically dependent grantor by an individual with improper motives as a result of undue influence or in a situation of suspicious circumstances for the sole purpose of abuse, exploitation, and personal gain. And so let's go through some case examples. In the Nugent and Nugent-Crawford case, there was a situation where a power of attorney document was found to be invalid and procured as a result of undue influence. The grantor of the power of attorney did not speak English, and the translation of the planning document was only provided to the grantor by the grantee, the proposed attorney. and in a relationship of dependence which existed between the two parties of mother and adult child. And in another case, the Graham and Graham case of 2019, where an older mother executed a will and a power of attorney a few weeks before she died at one of her son's requests. The mother appointed that son her attorney for property and left everything in her will to him, disinheriting all of her other children. The son provided the lawyer with all of the information for the will and the power of attorney, and not the mother. The mother advised the lawyer that she was making the son her attorney and sole beneficiary because of her other son didn't attend the funeral of her husband. This, of course, was not true, and not only did the other son attend, he arranged for the funeral and brought the food. The attorney then used the power of attorney to transfer the mother's assets, her house, which was her significant asset, into his name. The court found that the attorney's son had orchestrated virtually every aspect of the will and power of attorney, and the will, POA, and house transfer were in the end set aside. So similarly, another example is in a scenario where an older adult parent is ping-pong back and forth between adult children and competing power of attorney documents are produced. Parents never want to make waves, and time again we see them simply agree to the procurement of successive power of attorney documents, and in turn there are disputes over control and access. So another case example is the Adler and Gregor 2019 decision, where a mother of two daughters executed powers of attorney for property and personal care in 2015, appointing one daughter as her sole attorney. After significant conflict between the sisters in September 2017, the non-attorney sister took the mother to a new lawyer, a lawyer the mother had never met before, and the mother executed new power of attorney documents appointing both sisters jointly as the mother's attorneys. An application was commenced to determine which POA documents, in other words, the 2015 or the 2017 documents, were valid, and whether the mother had capacity to grant either power of attorney documents. Competing capacity assessments were produced, which the court rejected as unreliable to the bias and influence of the sisters. They reviewed drafts, demanded revisions, corrected information. Ultimately, based on other evidence from doctors and nurses and friends who knew the mother, the court concluded the second set of power of attorney documents were invalid due to a lack of capacity. And so let's talk about a third situation where the power of attorney is used or misused or abused in situations where the power of attorney is fraudulently or imprudently used for self-purpose or self-interest. The use is unauthorized, it's often questionable, and speculative investment decisions are made, or simply blatant misappropriation. In the rather sad case of McMaster and McMaster, a mother appointed her two sons as joint attorneys under a continuing power of attorney for property. She decided to not tell, or indeed she forgot to tell, one of her sons that he was also an attorney. The son, who knew he was an attorney, had access to all of his mother's assets, used her life savings to invest in a rather dubious business venture. It was a go-kart business. By the time the other son figured it out, the mother's assets were depleted by almost $2 million. The court had no hesitation in removing the son attorney and ordered that he provide an accounting for the money taken. But the court also had this to say: Mary, the mother, is the embodiment of an individual who needs protection of the court. Otherwise, she is a pawn in the investment schemes of her son. The fiscal stewardship of the son had been a disaster for his mother. He has literally blown through at least $2 million. If there was ever a case for removal of an attorney, this is it. It will prevent the further hemorrhaging of his mother's assets. And the son was ordered to pay over $25,000 in legal costs. In another decision, the Gironda and Gironda decision, an elderly mother appointed her son as her attorney under a continuing power of attorney for property. He decided it was okay to use that POA document to transfer $175,000 from her bank account into his own bank account. He then decided to use the power of attorney document to transfer all of her property to himself, her real property, for $2. Unfortunately, these sorts of power of attorney disputes are prevalent. These documents are misused and abused time and time again, causing a grantor harm through fraud, neglect, and depletion of wealth. This is accompanied by negligence in the provision of necessary care, care requirements or obligations which are not necessarily under a power of attorney, fights over property management, the use and depletion of family wealth, children arguing over a division of parental assets before death, unequal gifting, loans. All of this is becoming more commonplace. Situations of conflict also often arise where the grantor of a power of attorney document never fully understood the nature and extent of the powers granted, never thoughtfully considered the chosen attorney, never considered whether the chosen attorney could be trusted to act honestly. If things go wrong, there are ways to attempt to fix the problem, but let's be clear, there is no easy solution here. These are very complex situations. Often the process involves lengthy and expensive litigation, either in the criminal context, if the evidence is there for criminal charges to be laid, or in the civil context between individuals, or both. The case I discussed a few moments ago involves situations where families of an incapable person took a perpetrator to civil court to try to get back the stolen or misappropriated money, to remove the attorney, or to have the power of attorney document or improper property transfers set aside. Criminally, there are several charges that can be laid against an attorney under a power of attorney document where there is theft or misappropriation of money using a power of attorney document. Besides the usual theft provisions under the Federal Criminal Code, there is also a specific provision, Section 331, theft by a person holding a power of attorney. This provision, however, appears to be underutilized. I'm not sure why. It was discussed in one case, the Crown and Kajik, where a son used a power of attorney document to rob his mother of all of her assets. She had held assets and various real properties in excess of $1 million at the time her husband died. The son used the power of attorney document to mortgage her various properties and defaulted on all of the mortgages. The mother was left penniless, living in a homeless shelter at the time her son was brought to trial for this awful crime. The son was sentenced to 10 years in jail, which was reduced to 8 years on appeal. And the court observed this. This was a despicable breach of trust, a fraud, as the offender was, at the time, the power of attorney to the victim. The victim was the elderly mother who was extremely vulnerable to him as her only child. Mr. Kajik would rip off the wings of all of the angels in heaven and sell them to the devil for his own gain if he could. In jail, this offender will be better off physically than his own mother. He will be sheltered, he will be fed, he will regularly be kept warm. So now I'm going to talk about some tips to consider that may preempt some of these situations. So what are the things that we can do? As lawyers, we can educate the client on the power of attorney document as a planning tool. We can ensure that we meet the client alone and in person for instructions. And I'll talk a little bit in a minute about the pandemic-related issues arising out of trying to meet our client alone. We can be live to issues of capacity and undue influence. Know that they exist. Probe the client where accompanied by another person who appears to be overly involved in the older adult's affairs. We can consider social isolation, recent bereavement, family conflict, and make sure we make inquiries. Assess and make note of any obvious impairments, memory issues, disorientation, poor attention, decisions not supported by reasonable explanation. Review why the grantor is making a power of attorney document at first instance. Is this the first time that the grantor is making a power of attorney document, or is there a revocation? Discuss the choice of attorney, residency issues, jurisdictional concerns, family dynamics. If choosing multiple attorneys, why? Should the document appoint joint or joint and several attorneys? Make detailed, dated notes. Mark the meeting start and end time, and make sure that you are complete in your file records. Litigators may consider dissuading clients from litigating. Strategize and devise a tailored conflict resolution plan short of litigation. Consider the exposure to costs and the means of the client i.e. the financial implications, which often mean that litigation will not fit the client's circumstances and will inform their choices in terms of how to resolve the dispute. Consider the health, the age, and stage of the parties participating, including the subject matter of the dispute. Does the dispute resolution plan make sense? Will the court process effectively resolve the dispute in a timely manner, or at all, given the considerations and the legislation and the case law? Who is best suited in the dispute to take steps to facilitate the resolution? Is it an adult child? Is it the older adult parent? Or is it someone else? Consider applications for advice and directions under the Substitute Decisions Act, seeking mandatory mediation of questions involving the power of attorney document without resorting to inflammatory allegations and assertions and approaching any litigation in a scorched earth manner. On a final note, before I move on to scams, it's clear that courts have little patience for sibling rivalry, even where well-intentioned, and indeed courts are not empathetic to the costs incurred. Notably, very few people will have the money required to fund these disputes to completion, especially when knowing that absent particular circumstances, the incapable person's assets will not be used to fund this sort of litigation. So now let's turn to some scams. Notably, no person is shielded from becoming a victim of a scam or a fraud. Fraudsters target anyone and everyone, and they're constantly coming up with new scams. However, older adults tend to be more vulnerable to becoming victims and easy targets, either due to lack of experience with technology or issues with diminished capacity or isolation, alienation, sequestering, and lack of support. There are a variety of scams that are happening right now, and the way people are being defrauded continues to evolve. Unfortunately, by the time people catch on and the government agencies and institutions warn the public, it's often too late. In 2019, the Canadian Anti-Fraud Centre responded to over 58,000 reports with over 22,000 victims who lost over $133 million. With the current pandemic, there has been an increase in frauds and scams, including those targeting older adult populations. The Canada Anti-Fraud Centre has received hundreds of reports from victims who have had their money or personal identification stolen during this pandemic. Since March 6 alone, the Canadian Anti-Fraud Centre has received 500 reports linked to COVID-19, where there were over 90 victims who either lost money, were hacked, or had their personal information stolen. Scams have emerged to take advantage of people during this public health crisis. Let's talk about a few of them. Phishing is at the top of the list. This is a situation where mass emails or text messages are sent out asking people to click on links. Links offering COVID-19 test kits, for example, free face masks, hand sanitizers, or even miracle cures. The sort of items in high demand, as indicated by the senior RCMP intelligence analysts with the Canadian Anti-Fraud Centre. These links are often laced with malware, or they're extortion emails where the victims are told their computer has been hacked and they were caught committing sexual acts on camera. There are also merchandise scams where you can order, for example, free masks, but told you would have to pay for shipping and provide a credit card. Unauthorized charges then appear on the credit card, or no masks are ever shipped. Community helping scams, callers saying that they are trying to connect with socially isolated seniors during the pandemic, but in some instances these calls are predators who are actually trying to identify vulnerable seniors so they can get into their house, sell them things, or steal personal information. Although please note that there are legitimate community helpers who are really just trying to help. Distinguishing between the two of them often is difficult, however. Outside of the new pandemic scams, other common scams perpetrated against older adults include charity scams. These are scams where fraudsters collect money by pretending to be a real charity, either on the street, door to door, or over the phone. In COVID-19, a popular one has been fake emails claiming to be from the World Health Organization asking for donations to fight COVID-19. Emergency scams. These scams usually target grandparents, and the fraudster pretends to be a grandchild who calls to say that they are in trouble, that they've had a car accident, are in jail, stuck in a foreign country, and then they need money immediately. The victim is often sworn to secrecy, with the fake grandchild claiming embarrassment and fear of other family members or others finding out. And romance scams. It turns out that Canada is very romantic. These scams occur through dating websites where a scammer sends a few messages and a good-looking photo of themselves or who they claim to be. And once the victim is charmed, the fraudster asks them to send money, claiming that there's a sick family member who needs help, or that they need help or money for one reason or another. Once the money is given, the person often disappears. Romance scams cost Canadians more than $22.5 million in 2018 alone. Prize scams. The victims in prize scams are contacted via email, phone, text message, etc., and told that they have won a prize or a chance, or they have an opportunity to win a prize. The winner must first purchase something or pay an advance fee, such as taxes, to receive the prize. In 2018, Global News interviewed an older adult who had been diagnosed with early signs of dementia and had lost about $140,000 after becoming a target of a fake suitor who stole her money. After her husband died and she was feeling very lonely, the older adult joined an online dating site, Match.com. The imposter began his aggressive pursuit online, sent her pictures of himself, and listened to her issues. Once she was hooked, the money request started. Initially, he requested $12,000 US. She sent it. Then he wanted $80,000 US, and he claimed he had been jailed in India. She sent this money despite her bank manager advising her it was a scam and she should definitely not send the money. Only when the fraudster asked her to send money for the third time would she accept that she had been scammed and went to the police to report it. But by that time it was too late. The scam cost her her independence. She had to move out of her house. She had to sell her car. She could no longer afford to live there. She knows that retrieving the money is almost impossible, but she wanted to tell her story to be heard in the hopes of warning others who might fall victims to such a scam. So now let's take a brief look at the virtual signing of wills and powers of attorney and the risk associated. Some new and interesting changes have happened in the estates and elder law field due to COVID-19 and social physical distancing measures which are now in place. The Government of Ontario issued an emergency order in council permitting the virtual witnessing of wills and powers of attorney for property and for personal care. In order for a will or power of attorney to be valid in Ontario, it must be signed by the person making the will or giving the power of attorney in the presence of two witnesses. These are specific rules in the existing legislation about who witnesses can be and how many witnesses must be present. Normally, this requirement means that all three parties must be physically together when the document is signed. If not followed, the will or power of attorney may not be valid. However, now virtual witnessing provides flexibility to allow more people to sign their wills and powers of attorney while staying safe. The emergency order states the requirement that a will or power of attorney be signed in the presence of two witnesses, which may be satisfied by means of audiovisual technology. Audiovisual technology is defined as any electronic method of communication in which participants are able to see, to hear, and communicate with each other in real time. This would include, for example, Skype, or FaceTime, or Zoom. The person signing the document and the two witnesses must be able to see and hear each other at all times when the documents are signed. Importantly, a will or power of attorney that is signed in the physical presence of two witnesses does not require that one of the witnesses be a lawyer or a paralegal. However, in order to ensure that virtually witnessed documents are signed correctly and to safeguard against concerns of lack of requisite decisional capacity or undue influence, The emergency order requires that at least one of the witnesses to a virtually witnessed will or power of attorney must be a licensed lawyer or licensed paralegal. Further, on April 22nd, the emergency order was amended to allow wills and powers of attorney that are witnessed virtually to be signed in counterpart. This means that complete and identical copies of documents can be signed separately by the testator or the grantor and the witnesses at the same time. This allows for one meeting to take place instead of additional meetings to have the same document executed by the testator or grantor and witnesses. Nevertheless, the emergency order does not allow for the use of electronic signatures. The signatures still have to be original. There is no specific date for when this emergency order allowing virtual witnessing will end. It simply specifies it ends when the emergency is over. Lawyers should monitor the status of the order carefully so that they do not serve as a virtual witness after the order ends. LawPro, which is the lawyer's professional insurance provider, warns of the potential problems that could arise if lawyers are just parachuting in at the last minute to act as a virtual witness. So be cognizant of this. For example, the will or power of attorney was not executed properly. If you act as a witness, lawyers need to be prepared to be held responsible if the execution requirements are not followed. There are very specific requirements for execution. The testator and witness must still be in each other's presence, albeit by audio-visual technology. If one of you does not have a working web camera with audio or smartphone, then you cannot proceed. Preparation of an affidavit of execution as the lawyer witness, it is likely that you will be expected to assist or arrange for the affidavit of execution. If you do not want that responsibility, it should be made clear at the outset. If the will was prepared by the testator alone and not with the assistance of the lawyer, there is a chance that the will or the power of attorney does not reflect what the testator or grantor really wants. If the lawyer has only limited communication with the testator or grantor, it would be more difficult to assess if someone is exerting undue influence on the testator, or if the testator has the requisite capacity to execute the will or power of attorney. Some things to keep in mind for lawyers when virtually witnessing a will or power of attorney document. And on this note, you'll note that we have a checklist on our website, and you can access it to address this situation. So remember to confirm the identity of the client. Get photo ID prior to the video conference. Ensure the document being read through and signed by the grantor or testator and the witnesses is the same document, that you're all working from the same document. Arrange to have the executed documents immediately returned by courier to the law office or your working from home office to ensure the documents are not misplaced. Ensure that the execution statement and affidavit of execution references the circumstances of signing. Be mindful of capacity issues and the potential for undue influence, which is what we're going to talk about next. So, undue influence and video conferencing. Inter vivos undue influence or testamentary undue influence should be top of mind during the current environment when interactions with older adults is more often completed virtually. The doctrine of undue influence is used by courts to set aside certain inter vivos, meaning while a person is alive. So inter vivos gifts or wealth transfers and transactions, as well as planning and testamentary documents where, through exertion of the influence of the mind of the donor or the grantor or the testator, the donor's mind falls short of being wholly independent. Where one person has the ability to dominate the will of another, whether through manipulation, coercion, or outright but subtle abuse of power, undue influence may be found. When virtually meeting with a client or consulting with a potential new client or witnessing legal documents over a video call, in addition to the usual red flags and indicators of undue influence, again, full checklists can be found on these subjects on our website. You want to make sure you keep in mind the following. Is there an individual or individuals who are with your client in the same room during the video conference? Try to interview the client alone. Explain the importance. Determine what technology the potential client or client is making use of. For example, is it a laptop? Is it a desktop, monitor, mobile device? Ask, if able to do so, that the potential client or client do a 360 view of the room where they are sitting. So you can see if anyone else is in the room and you can see the layout of the room. Request the potential client not mute the meeting during the duration of the meeting. Request that any doors, if applicable, be closed during the meeting. Observe body language closely. Listen for rustling papers or other distractions and making inquiries if possible. If someone insists on being present in the room, establish who that person is and why they are there. What is the relationship as between that individual and your client? Who is your client living with during the pandemic? Analyze the room in which your client is taking the video call. Does it look disorganized? Observe for cleanliness and disarray. How is your client dressed? Does it raise any red flags about personal hygiene and care? Is your client looking at the camera or looking off in another direction for answers, for example? Is someone writing down and holding up written answers for your client to read? Try to make sure your client is the one answering the questions, and if on video, that you see all of the person as much as possible. Does your client have any documents in front of him or her? What do those documents say? Ask. Who wrote the documents? Make sure you ask. And direct, pointed questions to your client. Are there any communication issues that need to be addressed? Can the client hear and see you clearly through the video conference service? And can you hear and see them properly? Test this through questioning. Are there any language barriers that could limit the client's ability to understand and to appreciate the documents being considered or drafted, or otherwise as applicable, and the related implications? Do you need a translator? Do you need assistance to overcome language barriers? Who set up the video call? Is the client technologically sophisticated or savvy, or did someone else set up the call or consultation? Who? Why? What are the circumstances? Is the client aware that he or she is paying for the consult, or that the consult is being paid for with his or her assets? Consider using the record function for the video call and establish this protocol from the outset of the meeting. If you intend to record a client meeting, the Law Society of Ontario has confirmed that you have a duty to inform your client before recording them, and you should also inform others present in a meeting of your intention to record. Some of the benefits of recording allow you to capture the client instructions, focus on listening and observing visual cues rather than note-taking. You can transcribe important or complex information after the meeting, and you can then demonstrate the process followed for the virtual meeting rather than simply documenting it. Obviously, there are risks associated with recording, so make sure you are properly able to store the video so it cannot be accessed by others, and also some clients may be less open and honest if they know that they are being recorded. Back up the files so important client meeting information is not lost. If you are not recording, make sure you take detailed notes. When meeting with older clients, it is my own personal preference to ensure that I have another lawyer there at the same time taking notes so that I can concentrate on addressing visual cues. Contemporaneous notes can also help refresh recollections, help to see if there is something you want to stress in follow-up correspondence, and is an excellent tool when defending claims. Send a detailed reporting letter. Confirm what the scope of the retainer was. Detail any legal advice that was given, and note if the client indicated if she or he was not going to follow that advice. Lawyers should be on guard and hyper-vigilant during these pandemic times. Unscrupulous individuals may see this as an opportunity to unduly influence or coerce dependent older adults into changing their planning documents, wills, or other testamentary documents to benefit the influencer. So this is just a snapshot of some of the issues covered under elder law. Other topics include ageism, decisional capacity issues, testamentary capacity, capacity to marry, capacity to gift, guardianship applications, statutory guardianship, risks of predatory marriages, end-of-life decisions, and medical assistance in dying. All of these topics are covered by our book. Older adults are disproportionately vulnerable to abuse and exploitation, and we must all keep an eye out for the vulnerable in our society and understand the red flags, not just as lawyers and not only lawyers, but also other types of professionals, community professionals, and the community at large, and in particular financial institutions and medical professionals and the police. Lawyers in elder law are experienced in understanding the laws and ways to protect our older adult population. Elder law is an important and increasingly busy area of law. I hope I have assisted in providing you with some information for your use and dissemination. And again, I would refer you to the resources page of our website. Two other additional resources which I think are very helpful, which you can also download, are the Toronto Police brochures, Elder Abuse and Neglect, and Social Isolation of Seniors. Thank you for listening. I encourage you to download a copy of our book by PDF on our website on the publication page if you wish to receive a hard copy of the book. If you could contact our offices to the extent that we have any left, we'd be happy to send one out. Thank you for listening and take care. Stay well.